welcome to Matrix Mediation.
Hi, my name is Amber McMichael. I'm here with my client, Dr. Constance, for the Constance harmonic car.
Certainly. Okay, Mrs. McMichael, I have you right over here in this room. And can I get you some coffee or water, anything to drink?
Oh, water for me, please. Mrs.
Same.
Constance.
Thank you. Certainly. Hi, good morning. Welcome to Matrix. How are you doing?
Thank you. I'm here for the mediation and harmonics. My name is JenAni. This is my client.
Hi, nice to meet you. Let me just get you signed in. All right, right this way, Mr. Methe. You're going to be right in here.
Thank you.
And can I get you some water, coffee, anything to drink?
No, I'm fine. Thank you.
I'll take the water. Certainly. Be right back.
Hi guys, you all ready for them to begin? Can I bring them in?
Yeah, absolutely.
Okay, come on in. Dan, Nichole.
Thank you.
Does everybody know everybody?
Yes. Hi, Dr. Constance. How are you?
Good, how are you?
Good.
Okay, good afternoon everybody and welcome. First order of business is if we can just go around the table real quick and have everyone introduce themselves, starting with you, Amber.
Good afternoon. My name is Amber McMichael. I'm plaintiff's counsel here with Dr. Constance, my client.
Hi, I'm Dr. Constance.
Nice to meet you, Doctor.
Hi, my name is Methe. I'm here on behalf of Harmonica Sports Bar, Inc., and I have my representative, Nichole Ludemann, here.
Hi, my name is Nichole Ludemann. I'm the corporate representative from Harmonica.
Nice to meet you all. Thank you for coming. My name is Rodney Romano. I'll be your mediator today. And the first order of business is to ask everyone, or ask counsel for yourselves and your clients, if you'll agree that we're traveling under the Florida Mediation, Confidentiality, and Privilege Act. I'll give you a hint. The answer is yes. So please say yes now.
Yes.
Yes.
Okay. And folks, that's just an extra layer of coverage to make sure that we all understand that everything that happens here is confidential, cannot be used by or against any party anywhere else for any other reason. And I'm still not a judge and can't make you do anything you don't want to do. I won't be handing down any orders. So what's my role here today is to try to help you explore the pros and the cons of all of the options you'll be presented with today so that you can decide what is in your best interest. Generally speaking, there's three ways that a litigation gets resolved. And it is 100% guarantee that your case will be resolved. The only real question is what will be the terms and conditions. And by that I mean you can settle today when the cost and the delay and the risk will never be lower, or you can keep litigating and pouring money on both sides into the litigation machine and settle the case somewhere along the way, or you can take the most amount of time, aggravation, and trouble and turn this case over to a jury of 6 well-meaning people and a judge who will impose their settlement on all of you. In that case, you get the opportunity to swing for the fences and try to hit a home run, but you also have the risk of striking out. Here at mediation, nobody gets everything they want, but they get enough of what they want and enough of what they need to make settlement sensible to them, while leaving enough on the table to make settlement sensible to the others. So the way we do it is, may I call everybody by first names, please?
Yes.
Okay. Amber will give a presentation first and teach us all about the plaintiff's claims in this case. And that will give Dan and Nichole an opportunity to evaluate not whether they agree or disagree, but whether they think a jury will buy some or all or none of what she's presenting. When she's done, Dan will give a presentation for the same reasons so that Dr. Constance and Amber can evaluate how they think his arguments would sell to a jury. Because what we're really trying to do is figure out not what anybody thinks ought to happen in this case, but what you, with your combined knowledge and experience, think a jury would probably do with this case if they get their hands on it, and then reverse engineer something that makes more sense than that today. When the attorneys are done with their presentations, I'll put you back in your own separate room so you can talk privately, and I'll visit back and forth between those rooms in an effort to help you find common ground today so a jury won't have to force it on you sometime in the future. if we do get the case resolved today, I'll pull up a settlement agreement that all parties, all the lawyers have seen before, so that they can change it to meet the needs of their clients in this case. And then you'll all sign it, and you'll leave here with a signed enforceable agreement in your hands, and the lawsuit, at least, in the rearview mirror. Any questions before we start?
No.
Amber, you have the floor.
Well, thank you everyone for taking the time to be here today. I appreciate it. I hope that we're able to get everything resolved. I think my client, she represents well. She's a great person, and I'm grateful to be here to assist her through this process. So thank you. We're here today because this is a premises negligence case arising from a slip and fall. My client was at your establishment with her friend having lunch. When they were done, she got up from the table and she slipped on this napkin. It wasn't just, she kind of slipped and caught herself. It was aggressive. I mean, she slipped so hard that she flew into another booth. She didn't just slip and catch herself. She slipped aggressively to the point that she landed into another booth. The napkin, it definitely was not from their table. There were only 2 of them there. There were 2 napkins that were still on that table. So clearly it was negligence on the establishment for not being able to go around and make sure that the floor stayed cleared. Due to that slip and fall, she injured her right hip, her right knee, her left hip, and her left shoulder. After conservative treatment failed, because she wanted to see if she could do this herself. As you know, my client's background, she is a chiropractor. She is a doctor by trade. So she did go the conservative treatment route, and it failed. She ended up having to have her left hip and orthoscopic surgery done on it, and unfortunately, that didn't provide much relief as well. So instead, she ended up having to go and undergo a total left hip replacement. As I said, she's a chiropractic physician, and a result of her injuries, she was forced to close her practice. She wasn't able to meet with her patients. She had difficulty, helping them. As a chiropractor, you have to be able to manipulate your patients, their bodies, their limbs, and she was unable to do that. So she actually had to retire early from her profession. Since the accident, she has had some well-documented injuries. She's had various tears and problems bilaterally in her hips, as well as her shoulder and her knee. She's already succumbed to 2 surgeries on that left hip. She's had the arthroscopy for, the labral tearing. She had the left direct total, arthroplasty, and she's a candidate for surgery for a meniscal tear in the knee, and a similar regimen for the right hip as she had on the left. At the time of the incident, she was 58. As she sits here today, she's 60. She's been working restricted hours. She does have carpal tunnel syndrome, but was planning to return to full-time work. She planned to work until she was at least 67 years old. Mind you, again, this incident happened when she was 58. Instead, she had to go on disability, and at her low of $14,000 in 2016, we estimate her past lost wages to be $70,000. Her full-time income prior to the carpal tunnel cutback in her hours was about $28,000 per year. If you multiply that by 7, her future loss capacity comes to $196,000 a year. I'm sorry, to $196,000. Her past medical bills total about $240,000. We estimate that her future care, she's going to consist of annual checkups. She's going to have biannual MRIs. She's also going to have intermittent pain management. She also might have to have possible injections and definitely physical therapy. She does require knee arthroscopy, and we estimate that the future expenses are going to be around $75,000. As I said before, makes an excellent appearance. She'll make a great witness. The deposition you did for her, I think she presented well, so I think she'll present well if we end up going before a jury. As a result of her injuries, she can no longer do her daily activities. She can't squat. She's unable to clean her house. She can't garden or walk fast the way that she used to. Even her sex life has been impacted by this. It's diminished. It's affected everything, not just her work and what she did for a living, but her life as a whole. Her lifting restriction is about 5 pounds, and she has to use a shower chair because she's scared she'll fall once she's in there. Again, she's only 60 years old. The economic loss, we believe, exceeds $580,000, and we believe a jury would have no trouble awarding at least $250,000 for the past pain and suffering, and an additional $250,000 for future pain and suffering, which places the value of the case in excess of your insured's $1 million policy. Like I said, we came here. We appreciate everybody taking the time out of their schedules. We look forward to trying to settle this case, but our initial demand is $1 million. And I thank you, and we look forward to hearing what you have to say.
Good afternoon, Dr. Constance. We met during your deposition. As you're aware, I represent the defendant in this case. I'm the defendant's advocate. It's just as your attorney is an advocate for you. So you're going to hear things during my opening that you may not agree with. In fact, you may disagree with a lot of things that I say. But it's important for you to listen to what I have to say, because for you to make an educational and informed decision regarding a settlement in this case, you need to hear what I'm going to say to the jury. So please don't be insulted by anything I say today, but I'm presenting the facts and the evidence most favorable to my client during my opening statement. In this case, I have two ways to win. I can win on liability, and if the jury finds that you're completely liable for the accident, my client pays nothing. Also, I can win on damages. If a jury finds that your injuries are not related to this fall and related to pre-existing conditions, there's a second way that I can win the case. So I'm going to try to explain the liability case first. And in Florida, there's what we call a slip and fall statute. It's basically a limitation of liability, and it protects businesses from the very kind of fall that we're here today for. It basically states that if you're a customer and you fall in a business establishment, you must prove that my restaurant had either actual knowledge of the napkin on the floor or had some constructive knowledge that this dangerous condition, the napkin, had been on the floor long enough for the business to have done something to pick it up. If you can't prove that, then we prevail. In this case, there's completely no evidence or testimony that this napkin had been on the floor in which any employee of the restaurant had any notice of. Secondly, there's no constructive knowledge. The napkin wasn't stepped on, it didn't have a dirt on it, it looked like it wasn't old and had been on the floor for a long time. In fact, one of the servers, that it was actually your server, had witnessed your fall and had just been in that area and did not see the napkin on the floor. She believes, and she will testify at trial, that the napkin came from your lap when you stood up. The napkin was fresh. There was no indication that that napkin had been on the floor before you got up. If that's the case, then the defendant wins. Now, we filed a motion for final summary judgment. We've asked the judge in this case that there are no material issues of facts in this case, and the judge should enter a judgment in our favor before we go to trial. And that's being filed as we speak. In this case, we took your deposition and you had no knowledge who created the condition, how the napkin got on the floor, or how long the napkin had been on the floor. Those three things alone would require the judge to enter a summary judgment in our favor, because there's no other evidence or testimony that the restaurant had any notice of the napkin. And it makes sense. If you were in your home or you were in a business establishment, if something had just fallen and somebody came by and slipped, why would the business be responsible for that? They would only be responsible if they had sufficient notice to have done something about it. In this case, they didn't. And therefore, we feel very strongly that we should prevail on liability. Also, I can win on medical. And what does that mean? Well, I have doctors that have examined you and have had your MRIs reviewed that were before and after the accident. We believe that evidence is going to show that you had pre-existing conditions that have nothing to do with this fall. And so what I'm going to start off with is some of the accidents that you've been involved in. You were involved in a couple of motor vehicle accidents in which you claimed the same injuries that you're claiming from this fall. You also injured your knee in 2001 and actually had an MRI scan of your knee. You went skiing and hurt your other knee. You have typical findings on MRI that show what we call degenerative changes, which is part of the aging process. As we get older, it's easy to see that I'm older because of the wrinkles and my loss of hair, but we also age internally as well. So our body looks older inside as we get older, and as a result, it degenerates. And you have typical labral tears in your hip that we find in almost anybody who hasn't even been involved in an accident. These are typical findings in people of your age. You have findings in your knee and your shoulder that are consistent with prior injuries that have nothing to do with this fall. Our MRI expert will show the jury MRI scans before your accident and show it after the accident and show no material change. In other words, the MRIs of your shoulder and knee would have looked exactly the same the day before your fall. And that's pretty convincing to a jury to see pictures and see what your knee and your shoulder looked like before and compare it to after the accident. So these are our experts that are going to testify. We've also had a board-certified orthopedic surgeon examine you and found that none of your injuries were caused by this fall. They were due to pre-existing conditions that were developed over time. Now, you might say, well, why do your experts are more believable than mine? I'm not saying that. You're going to have well-qualified experts. I'm going to have well-qualified experts. And it's a real guess as to who the jury might believe. It's always a gamble. That's why we come to mediation, because we never know with 6 members of our community's only qualification is not to be a convicted felon and hold a driver's license, who's going to take control of this case and decide the outcome. Today, we have an opportunity to take control of the outcome of the case by settling it. And I always find in these kind of cases, everybody walks away a little bit unhappy if it's settled. And that means you might have taken something a lot less than what you thought you deserved, and maybe the restaurant pays a little bit more than they should have paid. That's compromise. And without compromise, these cases can't get settled. We think, respectfully, that the judge may grant the summary judgment, which will be the end of the case. And even if that doesn't happen, we believe at the time of directed verdict, which is after the completion of your case, that we may be entitled to a directed verdict, and we may not even hear damages. So for these reasons, we're here to try to settle your case because of the risk of the unknown of a jury trial. But we feel confident at the end of the day that we will prevail. But we're here today to try to offer you some money to get this case settled. But thank you for listening. I know it's tough to listen to another attorney talking about your case that's so personal to you, but I appreciate you at least listening and at least taking into consideration some of the arguments that I may make to a jury when we decide to settle this case or not. Thank you.
Thank you, Dan. Anything to add, Amber, before we split up?
Yes, Rodney, I'd just like to reiterate that my client was deposed, and she has testified that the napkin that she slipped on, there was no way it could be hers, or even her friends that she was with, because when they got up from the table, there were 2 napkins that were still on the table. They didn't have extra napkins, and there was only 2 of them. So therefore, it's definitely the establishment's negligence on that napkin being there.
Okay. At this time, we're going to go the other way. Okay. Right. Okay, so Dan, what, if anything, worries you about this case?
Well, she does make a nice witness, and I think that sometimes checks off at least one box when the defense is trying to evaluate this case. But also, she's a doctor and a chiropractor, and she should know some of the things that I was talking about in my opening, that there are pre-existing conditions, and she should understand some of the MRI findings that we have presented, that before and after films. So that's what scares me. And of course, the high amount of medical bills also is a scary thing, but I think if we win the case on liability, we're not going to have to go there. And I think we have a very strong case on liability. I'm not sure we're premature going to mediation because our summary judgment hasn't been heard. If that's heard, then, we think we have a good chance with the change in the law. Summary judgment standard has changed now, making it easier for defendants to get summary judgments in these type of cases, as you know. So, we feel we have a very strong case. The fact that she said she fell on the napkin, wasn't her napkin, it doesn't matter. The napkin, whatever napkin was on the floor, looked fresh, it wasn't dirty, it didn't have stains on it. It looked like a napkin that had just fallen on the floor, whether it was the plaintiff or some other person. So there was no actual knowledge, there's no proof of that, and there's no constructive notice here at all either. The plaintiff failed to provide any testimony during her deposition which would help her in defeating our summary judgment. So we feel good about our case on liability. And we think we'll carry the day on our summary judgment.
Believing that you could win this case, are you here today do you think there's enough risk that makes it worth offering some amount of money to try to get the case resolved?
There's always some value because, it could take an appeal. It could be the cost of an appeal. We don't always get the right judge we want on a summary judgment hearing, and so, it could get denied and we'll have the cost of trying the case. So we're here with some money to help settle the case, but if the plaintiff is not realistic about her chances of losing on liability, then it's going to be a really tough case for you to settle, because we're not here looking to settle this case for 6 figures. And I think with the risk of a proposal for settlement that we've already filed, that she could be looking at a judgment that she'd be paying us our fees and costs if she loses. And we can win that on a summary judgment, and that case will be done, and she'll owe us money.
So I recommend that you kick me out and consider what you want to make an opening offer for. I'd recommend it be a number that gives you some room to move, more than a few moves. And also be thinking about a message you want me to take over there. Like, for example, do you want me right out of the box to tell them, look, they're going to have to come, you're not getting close to $1 million, or that type of a thing. And then, of course, I'll do whatever you tell me to do, as long as it's not illegal, immoral, or fattening.
All right, let me talk to my adjuster and find out what we want to do here.
All right.
So right now, we want to at least get them interested in settling, so we're going to offer $25,000. But I want you to let them know that that's kind of a representative of what we think is nuisance value in terms of the cost of having to bring the summary judgment and potentially having to go to trial, but that we feel that we have a very strong case on liability. And if they don't significantly drop, we'll be wasting our time, because we're not here to settle the case on full value based on 100% liability and 100% damages. I went through the tip of the iceberg and all the things that she's had wrong with her before the accident. Multiple accidents, ski accidents, general life aches and pains where she's had various treatments for knee and shoulder, which we think will be compelling to a jury if we outline it all out. So they're going to have to be very realistic here for us to get this thing done today.
Okay. Thank you. I'll see. Doctor, how are you feeling today? Tell me what's going on with you, if you don't mind.
I'm doing fine.
Okay. Can you give me some idea of, I understand that you had some injuries in the past and some since this. Can you give me some idea of how this fall has affected you?
Well, my chronic pain is worse, and now instead of having restrictions from my wrist injuries, I'm restricted because of now my joint restrictions, replacements. I feel like I could have gone back to work with just the wrist problems, but now I cannot. That means I will have to take Social Security sooner than I intended, so my monthly income will be much lower. Plus, these injuries have greatly reduced my mobility, and fear of falling and re-injury has caused me to self-restrict self-activities. I used to love dining out, dancing, and just my social activities with friends and family.
Thanks for that. It helps me get a better sense of you and how this injury has affected your life. They're starting out at $25,000. They seem to feel very, very strongly about liability. How comfortable are you with the notice issue in this case? Do you see it as a risk before the judge?
Not really. Not based on the only witness that they have. I mean, I think if it went for, the person I believe that they're saying were cleaning the tables, for all we know, the one cleaning the tables is the one who dropped it.
Mm-hmm.
So of course she's going to try and say that it came from my client so that she or the restaurant's not liable. So, I mean, I'm pretty confident that they had noticed they should have been checking the floors.
What do you think about comparative negligence? Do you think if they argue a white napkin on a brown floor, she should have noticed it too and not stepped on it?
Possibly. I mean, I could see that. There's a contrast. But still, it's not her full responsibility. I think comparative would be very, very low on that.
Okay. So they're starting at $25,000, saying that's reflective of how they see the case. Of course, we'll test that, but they're looking for a significant drop. They said specifically asked me to tell you they're not here to settle a case based on 100% clear liability or 100% verdict value, but they are here to compromise and pay you something. Of course, the choice to settle or not settle is always yours, Dr. Constance, with the help and advice of your attorney. But I always think it's a good idea to find out what their best offer is, to see if you can get them to stretch today, and then only then can your lawyer really tell you, if you take this amount of money, this is what will go into your pocket, and then advise you whether she thinks she can do a better job for you at trial, whether you should go to trial or settle. But she can't really give you that advice until she gets their best number, and we can't do that until we go through this process. Does that make sense to you?
Yes.
Okay, so I'm going to get out and let you guys talk about what you want to do next, and I'll go wait for you to call me.
All right, thank you. I talked with my client. We are here. We would like to get this resolved. We listened to everything you shared with us. So we are willing to come off the policy and move down to $900,000.
Yes.
Okay, 900,000 it is. Thank you. See you soon. So when you get kicked out of a caucus and you're just standing around doing nothing, that's a really good time to start preparing your settlement agreement so that it'll be 90% done, and all you have to do is fill in the numbers at the end of the mediation. People really appreciate not having to wait around for 15 or 20 minutes while you write up a settlement agreement at the end of the case. Okay, so Dan, they came down to 900,000. I know it's not where you want them to be, but it's a start.
Yeah, I'm just letting you know that, we don't have that kind of money to pay anywhere near that. With a pending summary judgment and the issues on liability, we just think that this case has a value far less than that if anybody's looking at it. And I think that they realize the weaknesses on liability as well. So how do we get there and how fast do we want to go? Mm-hmm. I don't want to do a take it or leave it number yet, but I think we're going to give you a number that's going to have to be with a message. And, and maybe we can do a bracket just so they have an understanding, maybe in a couple rounds, just to give them an idea what our range is, because, we're not in that high 900,000, 800,000, or 700,000 range.
Okay.
So, given that, I discussed it with my adjuster, that, we would like to do is, since we feel like we're negotiating against ourselves, we're going to just kind of drip it still, and we're going to go, in response to their demand, and go to 30. Because, we just feel like we're negotiating against ourselves because they're not really at a real number. That just assumes everything's going well for them. That's assuming they win liability and they win the medical.
What would be a real number that they would go to that would get your attention and say, okay, now we're not wasting our time being here?
I thought about that and trying to figure out how this case can be divided by 3. You know that the plaintiff's got to get his fee, or she does, and then we got to pay the medical, and then we also have to put something in her pocket. So, I think without the plaintiff attempting to negotiate those bills in advance of today, it's going to be a big problem because the number's so big. So I'm thinking they probably need something like 150,000 maybe to get it settled, just to make maybe 50 to the meds and 50 to her and 50 to her attorney. That's what I'm looking at, maybe at best.
So if they came under 5, would that be something that would get to your attention?
No, it really wouldn't, because let's look at our worst scenario. Mm-hmm. Let's assume I'm wrong about liability, and they do a comparative.
Okay.
What's the worst thing we do? 50-50? Mm-hmm. I mean, it's a napkin on the floor. Why didn't she see it? It probably was her napkin based on what our server's going to say. So even on a comparative, let's say the case is worth $1 million. On 50-50, that's still 500,000, and doesn't take into consideration of some of our medical defenses we have in the case. Mm-hmm. So I think they got to be below 500 for this to work.
Okay.
Well below 500.
So if I go in there and I say, look, if you really want to get the defendant's attention, in this case, they've gone to 30, but if you want to get their attention and have them feel like they should really roll up their sleeves and start working harder, they like to see your next move be under what?
I think it's got to be below. I think it's got to be at 500,000 or something close to it, because.
Is it okay if I tell them that?
Yeah, because we have a summary judgment coming up. We got a hearing coming up, and obviously the money's going to go away if we win. And,
sure.
And in today's environment, with the evidence that I have in this case and testimony, we're going to get an affidavit of our waitress. I think we have a better than 75% chance of prevailing on the summary judgment.
Okay.
It's a real risk for them.
All right. I'll go talk to them. Thanks. Okay. So They were disappointed that you came to 9, but life will go on. They came to 30, but they said, look, if you really want to get our attention, you need to be under 5 sooner rather than later. So they're saying they're certainly not going to 5. That doesn't necessarily make it so, but I'm not seeing anything in the room that makes me feel like they're scared of defending the case. They really like you a lot, Dr. Constance. They think you'll make a great appearance in front of the jury, and that's probably their biggest fear. As far as premises negligence cases go, most defense lawyers like them because they win them more often than they don't. But they know that a good client makes a big difference, and so that's their concern. But they're only willing to spend so much to buy off that risk. He says that he's a little bit concerned that you haven't dealt with the liens yet. I didn't want to speak out of turn, but I assume you have a good idea of what you can do with those liens.
We do.
And so you may want to make this your big move if that makes you feel comfortable, or you may want to kick me out and talk about it between the two of you, and then tell me what you want me to do. Keep in mind, I'll make recommendations that I think will get you the most traction in the other room, but I'm duty bound to do what you asked me to do, and I'm happy to do that. But if you're inclined to make a big move, this would probably be a good round to do it in, to kind of keep their minds in the game. I think I'm getting the sense that if you're above 500, they're going to start to feel like it's not going to go anywhere.
Okay. All right. Could I have a moment with my client? Thank you for giving us this few moments. So I talked with Dr. Constance, talked with my client. We know we don't have the perfect case. We know there's things we have to consider. We hear what they're saying. We would like to make the big move, but we don't want it to signal that we think our case is weak. So how would you suggest us making that move? Or do you have a suggestion for us?
So a lot of times, bracketing, if you'd like bracketing, will work in a case like this, and you can say, look, we're not prepared to come to 500 with you at 30, but if you'll come to 100, or if you'll come to 200, we'll come to 500 and move things along. And have me explain to them that, look, there's some numbers, even although I don't know what you will settle for, there are some numbers you can't settle for because you have to pay the lawyer, pay the medical bills, and put money in Dr. Constance's pocket.
Would you give us another moment so I can discuss that? All right. So I explained what the bracket was to Dr. Constance. We do like your suggestion, so we will meet them. We'll do a 500 to a 150. We will go to 500 if they'll come to 150.
And normally when you suggest a bracket, you're signaling that you would take or that they would pay the middle point. So that's 650. That puts 325 in the middle.
And yes, I discussed that with my client, and if that's exactly
okay.
what we're.
It's just that people always look at the middle number, even if you tell them not to. They always do. So it's better to do a bracket that puts a number in the middle that you're comfortable taking if they pay it.
Thank you.
Okay. You're welcome. Okay, so big move from them this time. They wanted me to tell you they heard what you're saying. They're here to try to get it resolved. She has a good idea of what she can do with the liens, and she'll get a discount. I don't know how big it will be, but she'll get a discount that shouldn't interfere with the settlement of the case. They are proposing a bracket to you. They will go to 500 if you will go to 150. They understand that the rule is they're signaling the middle number, so they're sending you a signal over that they'll take 325 if you'll pay it. I'm going to take a wild guess. Are you going to pay it?
No.
Okay, thought not.
No.
I would suggest that you kick me out. And oftentimes in a case like this, what's most productive once somebody starts bracketing is to do a counter bracket. Don't put your best number in the middle, but put a number in the middle that gives you room to move up. Because you'll be signaling the middle number too, that you would pay that.
Right.
So, and give yourself at least 1 or 2 extra moves before one side or the other has to say that's as far as we go.
Okay.
Okay, I'll get out now and let you guys talk.
All right, we discussed it, and we're going to reject their bracket, but we'll give a new bracket. We'll go to 75 if they go to 225. And the midpoint of that is 150. So I think I mentioned to you, the 3 buckets that I think the plaintiff's got to do. And that puts them at that 3 bucket strategy that I was coming in here with. That 150 is fair. It's not, I don't think it represents the value of the case to us, because I think we're going to win, but it represents probably, some of the expenses that we're going to have to go through and the experts we're going to have to bring and a potential appeal. I think Nichole and I can live with that kind of split.
Is this going to be a best, last, and final?
No, I like to see what they come up with, but
my only concern is that you're assuming that the fees are a third, and they're usually 40% when a case is in suit.
yeah, I'm thinking maybe she'd cut her fee only because of the risk of the summary judgment. I tell you what, if they want, and I'm going to let you handle this wherever you want. But if they would be willing to negotiate between our midpoints, that might, and I'm not committing to the midpoints of the midpoints. In
Okay.
other words, our midpoint is 150, their midpoint is what,
25.
325. So we can negotiate between those numbers, but we're not agreeing to settle the case between 150 and their midpoint.
Okay. Could I suggest that you just have me present this bracket, but then say, I think they would continue to negotiate, if you will, but I don't know how much farther they're going to go.
Yeah, I'd rather it come from you, and I'll let you handle it any way you want. You know where I'm looking for, where I'm striving. You can say this is a mediator suggestion, then maybe we can see if we can mediate between the midpoints of our brackets.
Okay, sounds good. Okay, so they're now into 6 figures. I'm happy about that. With a counter bracket, they will go to 75 if you'll go to 225. That creates a midpoint of 150. They did not say that's their last, best, and final. How close they are to their last, best, and final remains to be seen. But I would recommend that you make another move down, stick with the brackets, and see where that takes us. You're kind of in the zone, what I call autopilot, because you're now getting close to real numbers where the case will either settle or not settle. And it's not my place to decide where that should be or what that number should be. So I can't really make any good recommendations as to what your next number should be, because that's up to you. I would just recommend that you come up with a bracket that's not your very, very, very best, so that you'll have room to respond if they respond. And we just grind it all the way out to the end, and it ends up where it ends up, and at least you'll know what you have to work with, and then you can make an informed decision. Any questions for me before I get out?
No.
All right, so the bracket was 75 to 25, midpoint 150. So,
And your midpoint was 325, just to.
right. So the thing, we haven't shared with you yet, Rodney, is the health lien that we're dealing with is an ERISA lien. So it's not, as you know, very negotiable as some of the others. So that's really, what we have to take into consideration.
Can I have permission to share that with them? It would be discoverable anyway, but sometimes it helps if I can say, hey, she's not going to get much of a discount on the ERISA lien.
That's fine. I think that's fair.
Okay.
So we're at 325, 150.
How would you feel about taking your midpoint down to either 300 or 275? Kind of anchor the 150 and just take something off the top.
Would you be okay if we, instead of doing our midpoint to their midpoint, going at 300?
Yeah.
Okay. So we would do 300 to, I guess you want to do they're 150?
Yeah.
Okay.
300 to 150, which is 450, which is 225, right?
Yes.
Okay, and I'll tell them about the ERISA lien. Okay, thanks.
Thank you.
It's getting interesting now. They went to a bracket of 300 and 150, big move. That puts 225 in the middle, but they did want to say that they wanted me to tell you that the health insurance lien they have is an ERISA lien, and they're telling me that those are very, very difficult to negotiate. That's pretty much what everybody tells me. I don't handle them myself, but
So her response to our bracket was to give us another bracket, right? So the
Yes.
midpoint's 225?
yes. So she dropped from a midpoint of 325 to a midpoint of 225. She made a big jump.
Well, that's encouraging. I mean, I'm glad to see that there are more realistic numbers. The problem we have is that we have such a good case, and do we sell it or buy it so cheaply? It's, not expensively, by paying $175,000 or $200,000. Seems like a lot of money on a summary judgment that we may win on.
Sure.
But then again, the number's going to go up if we lose on the summary judgment.
Yeah, that will certainly embolden them.
Well, what would you suggest?
I think this might be the time, if you are willing to go north of the 150, which was your midpoint, you could either say, look, 150 was our number, but if you tell us 2 gets it settled, or if you tell us the midpoint, we'll meet you halfway between 150 and 225, which I think is 187.5. You could do any of those things and say, but that's as far as we can go.
Well, I talked to Nichole about this, and we came here with 150, just to let you know. But a lot of times you have to make a phone call, which we're willing to do, and I think Nichole's made a phone call, and I think we can go north of 150 and we can get it done. So the numbers that you're talking about are probably something we can live with, and I'll do it the way you think, because the temperature in the other room. So how would you suggest we go forward to get to that 185 mark?
You could say, look, our number's 150. That's where we had the case evaluated. You're showing us 225. If you're willing to meet us in the middle, or have me say,
Split the difference.
If you're willing to split the difference, we'll split.
All right, we'll do that.
Okay. All right. Okay, so they had the case evaluated at 150. That's what she came to spend. She did make a phone call before I went back in there because they didn't think that was going to be enough to get the case settled. You showed them on your last bracket 225. If you're willing to split the difference and go to 187.5, they are too.
Are you willing to? I am. Okay. We'll take that.
Thank you. We're settled. Thank you, everybody. I'm glad we were able to get the case resolved today and move forward without this lawsuit. Great. Thank you for coming to Matrix, and we'll see you soon.
All right, Dr.
Hopefully
Constant, I'm glad the case
Thank
got
you.
settled. Good
Thank
seeing
you.
you again.
Thank you.
All right, thanks. See you next round.
Yes, definitely. Thank you very much.
Thanks, guys.
Thank you.